State, you may resume with your examination of Dr. Clark at this time.
Publishing 25. And doctor, you should have a pointer. All right, explain what we're looking at in states 25.
As part of the examination, particularly in gunshot wounds, we like to know whether the bullets are still in the body or how badly they are broken up, etc. So we do X-rays, and this is an X-ray of the head. You can see the top of the head here, the jaw, right side, left side, and these really bright spots here and here are the bullets that we recovered from this individual. They come out because they're very dense. The X-rays bounce off and turn them white here, just like bone. It's fairly dense. These are the bullets here, here and here.
Published states 26, please. How many bullets were in Mr. Markel's head?
There were 2 bullets in his head, and you can see on this one here that hit the left cheek, actually fragmented a little bit. And then we had a bullet inside the head, back to the left side, right side, excuse me, right side.
States 27. What are we looking at here, doctor?
This is actually the identification photograph of the individual. We like to get them cleaned up. We'll put the identifying tag underneath their chin, the case number, the date, and usually my initials. And you can see that there has been quite a bit of damage here, particularly in the left side of the face. We have a gunshot wound here that's labeled number 1 in the autopsy report, and this is number 2, labeled number 2 in the autopsy report.
By labeling them 1 and 2 respectively, are you opining that that's the order in which those shots were fired?
No, the numbering system in the autopsy report is just for me to discuss during the trial.
Publish 28, please. What does 28 show?
So this is what I call gunshot wound number 2. And you can see it's quite irregular. It's not a nice round hole you'd like to see, but the way it hit the bone, it caused a lot of damage and tearing in this area here. You can see that there's some what we call raccoon eyes or hemorrhage around the eyes and quite a bit of swelling going on here. Also in this area here, you see a lot of minor superficial abrasions that vary in size. Some are much bigger and some are much smaller. You can see it's all over the cheek here, so, and the ear and the side of the neck here. This is what we call pseudo-stippling, and this usually happens after the bullet goes through a door or a window or hits concrete and causes those items, the glass or the wood or the concrete, to splinter and cause small particles to fall out, to shoot out and hit the individual's skin. So this isn't true stippling, which is due to gunpowder, and we'll see an example of that in a minute. But so we have large areas of pseudo-stippling around the left side of the face and left side of the neck and ear.
So each of those small red injuries represents a piece of glass striking?
Piece of glass, yes ma'am, or part of the bullet that fragmented off the main part of the bullet.
States 29, please. What does this one show?
Again, we're looking at the left side of the neck here. Here's the left ear. You can see that this pseudo-stippling is quite extensive. Also, you'll see that there's kind of a purplish discoloration here. Because of where the bullet track went to, it caused a large amount of bleeding into the left side of the face, where you saw that huge distortion of the left side of the face, and then drained down into the neck.
States 30.
Okay, this is going to be gunshot wound number 1. It's right between the eyebrows, closer to the left eyebrow. Again, it is distorted. It's not a nice little round hole because of the shelf of bone that's there. It's called a glabella. So it causes an irregular entry wound. And now we're seeing a much finer area of stippling across the forehead here. This is much different from what we're seeing on the left side of the face. This is true stippling or gunpowder stippling from the barrel of the gun directly.
How does firing a gun cause this pseudo-stippling?
The stippling.
Stippling.
Okay, when the firearm is discharged, out of the barrel comes the bullet, of course, hot gases, soot, burning and unburned gunpowder. What causes the stippling is the burning and unburned gunpowder. It actually it's a particulate that strikes the skin and abrades it. It doesn't burn it, but it hits it and abrades it, or scrapes it. So that usually with a handgun, we can see the stippling out to about 18 to 24 inches. This to me looks a lot closer than that, but all we're seeing is the stippling here.
So the presence of this evidence suggests that the muzzle of the gun was quite close to Mr. Markel's head when it was fired.
Yes, I'm thinking inches. Yes, ma'am.
States 31, please. What does this show?
Okay, this is giving you a perspective of the two gunshot wounds here. What I call labels 1, what is label 2, the pseudo stippling on the nose, the fine stippling on the forehead, the hemorrhage around the left eye, part of the raccoon eye pattern.
States Exhibit 32.
This is the left forearm, and what you see here is kind of a ring of soot, partial ring of soot here, and some stippling on the forearm here too.
What is that consistent with?
That to me is suggested that that arm was up near the gun when it was discharged. That's at one point in time, and most likely the one gunshot wound that went to the center of the head here, that arm was up in a defensive type thing or a reaction type thing, and the soot and stippling is actually not from the barrel, but when you're talking about a revolver, you have a cylinder where the bullets are, you have a space between the cylinder and the barrel. It's called a cylinder gap. And soot and gunpowder can come out of the cylinder gap and cause this kind of pattern.
So again, consistent with the firearm being very close to the victim?
That's correct.
And also, is it consistent with the victim at least having enough wherewithal of the impending danger to raise his arm in defense?
In my opinion, yes, ma'am.
All right, and you said that the number that you order the shots for purposes of your reports does not necessarily mean that's the order of the shots that were fired in this case. Do you have an opinion as to which shots were fired in what order?
Yes, after discussions with the investigators and looking at the scene photographs, the first shot went through the closed car window. So the first shot would have been to the left cheek area, which traveled from the left cheek just before the left ear, hitting soft tissues, fracturing the jaw, fracturing the left cheekbone. Again, this is maybe slightly incapacitating, maybe stunned him, but would not immediately put his lights out. Okay, so that is where all the pseudo stippling's coming from that glass shattering. Glass is not there anymore. The second shot is to the forehead, where the actual gunpowder can strike the skin, and the hand was raised somehow into the vicinity of that cylinder gap.
And that's the second shot is the one that was not survivable?
That's correct.
And was there any amount of medical attention that could have assisted Mr. Markel, say if it had gotten there sooner?
Well, these are pretty devastating injuries, particularly the gunshot wound in the brain.
Did you collect the projectiles from Mr. Markel's head?
Yes, I did.
I'm going to show you States Exhibit 127 and 128. If you will publish 33, please. Ask if you recognize 127 and 128.
Yes, I do.
How do you recognize those?
These are the envelopes that we place these bullets in with the identifying marker labels and where they were from. Both one's from gunshot wound number 1 and one's from gunshot wound number 2.
Are they in the same or substantially the same condition as when you collected them?
They appear to be so, yes, ma'am.
Move into evidence 127 and 128, Your Honor.
Any objection? There you go. States 127 and 128 are admitted.
And is this a photograph of one of these projectiles removed from Mr. Markel's head?
Yes, ma'am. This is the one from gunshot wound number 2 to the left cheek area. If you remember on the x-ray, it had kind of a barrel shape to it. I don't remember, but you see the barrel shape here.
And for the record, that was 33, now publishing 34. What does this show?
This
Would
is
you be able to turn it? Upper left, maybe? Again. Thank you. What does
this is the
show?
bullet that we pulled from the right side of the brain. On the x-ray, it's getting a little pretty deformed. You can see that we taken one picture, one aspect of it here. Here's the identifying label.
What is meant by the term cause of death?
That is how that person died.
All right, and is it part of your job as assistant medical examiner to determine a cause of death?
Yes, ma'am.
And were you able to do that in this case?
Yes, ma'am.
What was the cause of death?
Got gunshot wounds of the face and head.
And what about manner of death? What's meant by that term?
Manner of death is how what were the circumstances that eventually led to the death.
And do you have an opinion as to the manner of death?
Yes, I do.
What is it?
Homicide.
No further questions.
Cross-examination, Dr. Clark.
No, Your Honor.
Judge, this witness can be excused, and this might be a good time to take our lunch recess.
Very well. Dr. Clark, you may step down, sir. Have a good day. Members of the jury, we are going to take our lunch break at this point. As you have been previously instructed, I'm just going to remind you again, you are not to discuss this case with each other or any other person. During your lunch break, you may eat together if you choose to. Again, you may converse about any manner of things, but this case. Does everyone understand this instruction? Please raise your hands. And for the record, the jurors have raised their hands. Please return at 1:15. Enjoy your lunch break. Before we go on the recess break this afternoon, I do believe this merits a small bit of discussion on the topic. The matters that we've discussed at sidebar concerning emotional responses, I do feel it is important at this point. Mrs. Adelson, when the testimony is occurring or the evidence, I know you may have a natural reaction, but as best possible, you need to control your reactions concerning any head movements, any expressions of disagreement, or any emotional outbursts. The jury must decide this matter on the merits, on the evidence. Do you understand this? Very well. I do not wish to do this in front of the jurors at all, but it's very important that you are able to control your emotions. Do you understand what I'm saying? Does either party need to be heard before we before we go into the lunch break?
No, Your Honor.
No, Your Honor.
All right, please report back at 1:15 as well. I believe we have 3 other witnesses that we can possibly get through this afternoon. That's fine. Go ahead.
With the break, the defense advised they've got some objections to my exhibit that I intend to introduce with this next witness. Today's exhibit 64 is email exhibit. It's a composite. And I haven't had time to look at all of the ones they're objecting to, but I know the first one is marked as State's Exhibit 64A. May I approach?
You may.
This is an email initially from Donna Adelson to Wendy Adelson, and Wendy replied March 28, 2011. It includes content in paragraph 3. Which is a discussion of Dan and his parents attempting to spend time with the kids and how annoying that is to Mrs. Adelson. You can read what it says. Defense is objecting to that item. On relevance grounds, relevance is that Mrs. Adelson hated the victim and that hatred extended to his parents as well.
Ms. Fulford?
This is while they're still together, Judge. This is 2011. It has nothing to do with Danny. It was a derogatory comment made by my client regarding Danny's parents. Wendy made comments and Mrs. Adelson made comments, and they're not relevant to this case. This is while Danny and Wendy are still together.
As to whether your client had any animus towards the deceased, is there a time period where it has to be within the divorce?
It's not animus towards the deceased. I'm talking about their comments towards his parents.
Ms. Kappelman, as it relates to the comments going towards the parents,
I think it's relevant, Judge. Goes toward motive. She did not want these children to be with the father and with the father's family. She wanted them with her and her family. And that's what happened.
That's not what this email says.
Right. No, it's not what the email said. It's not a confession to murder. It's a expression of dislike, which just goes to the motive.
all right. Much of this email does lack relevance or probative value for the jury. However, Ms. Kappelman, does this tie into other messages which otherwise would demonstrate the motive you're trying to prove? Or is this a standalone item?
I mean, there are other emails that express similar sentiments. I don't think they're specifically tied to the visit that's referenced in that particular email.
Are you arguing then that the defendant had a consistent animus towards the deceased?
Oh, yes.
Very well. Over objection, I will permit it only on the grounds that it shows that the defendant had a consistent animus towards the deceased or his family. However, if the defense is asking for a limiting instruction as to this evidence, you may request it now.
If we're asking, yes, we would ask for limiting instruction. This is not directed towards Danny Markel. I mean, if you take a look at it, Mrs. Adelson is complaining that Danny and Wendy have to schlep the boys down to see his parents instead of them driving up to see the boys. It has nothing to do with trying to keep the boys from the family. So I'm not sure what limiting instruction would be effective, but this is as to, it doesn't express any animus to Danny. So I'm not sure what the court would suggest.
Or his family.
The state's theory is not hatred towards Danny Markel's family. And so I'm
Ms. Kaplan,
confused.
as to the state's theory, please clarify this issue.
State's theory includes that Mrs. Adelson hated all things Dan Markel, and all things Dan Markel needed to be erased from these children's lives, including the grandparents. Now, I know Your Honor has precluded me from mentioning visitation with the grandparents and things like that, but obviously that's always been a part of the state's theory, and I understand that I'm limited from including that, but it is important to show that this animus existed as far back as 3/28 of 11. And this is the first item in the exhibit because it goes back the furthest in time. I think it's important.
We're not going to be wasting a lot of time on this back and forth. This is the point of pretrial motions. On this point, as it relates to the state's theory of the case, that the defendant had animus towards the deceased or his family, it will be permitted on those grounds. If the defense is asking in some way for a limiting instruction to be given, please request it now.
Yes, Your Honor.
What is the limiting instruction that is requested?
Your Honor, I'm at a loss. I think that an instruction that, I mean, this doesn't show hatred towards Danny. So again, I'm not sure. Obviously, I disagree with the state's argument concerning this. So I'm open to suggestions.
Be considered for the defendant's state of mind as it related to the deceased or his family.
I would ask that it be related to the deceased's family, because it's not to do with the deceased.
Ms. Kaplan. Well, down.
There's 5 more items, Judge.
Let's go through them.
Yes, sir. State's Exhibit 64D is an email dated 10/26/12. May I approach?
You may.
This email is from Donna Adelson to Wendy Adelson, showing her a list of prospective love interests from a website that Mrs. Adelson has identified as potential matches for Wendy. It's offered to show how controlling Donna Adelson was over her children's lives, how much she inserted herself into their private lives, and again, she likes to be in control of who they date and who they marry.
Response.
Judge, this is not an email from my client, Wendy Adelson. This is an email from Match.com to the email address that my client has. It doesn't say anything, the copy I have at least, doesn't say anything at all about Wendy Adelson.
Okay, I'll replace it with a copy that shows the email heading on the top, Judge. It's my fault.
And this was her forwarding this or actually including some sort of message?
She forwards it. I'm not sure if she included a message. She definitely did on the next one, which is also subject to Defense objection, it's State's Exhibit 64I, I'll approach with that as well, related.
What's the date on that?
What's the date on that, Ms. Kaplan?
1/17/13 today on Exhibit 64I.
Right. As to any questioning of Wendy Adelson as the role her mother played in her life, including screening potential romantic interest, that question certainly can be asked, but as to an exception to hearsay, what is being offered concerning this?
The relevance of it, or
Yeah.
the exception to hearsay is
Let's
the
go
statement
through
of a
both.
party. Relevance is that Mrs. Adelson was very controlling and micromanaging in their children's lives, particularly in their love lives, which directly relates to the motive for this offense.
Right.
Eliminated Mr. Markel. You get the idea.
I just can't understand how this would be material to this case in any way, anything that the state has to prove. That, you know, it's not, we just want to bash her reputation or what she did. They got to prove criminal offenses against her. How does her being on Match.com while she's living with her daughter have anything to do with something the state has to prove here? Nothing.
I believe this once again goes to the issue of motive. I understand the defense's position that you disagree. As to this motion, or excuse me, as to this item, this is you said 64I.
64D and I, Your Honor.
Right. As to whether the defendant in any way possessed a motive concerning Wendy Adelson, or excuse me, as it related to the deceased in controlling who Wendy Adelson may have sought as a romantic interest. Ms. Kappelman, do you have other evidence that's going to tie that to this particular item?
I do have other evidence that Mrs. Adelson, she's on the wire speaking about Wendy's love life and her current love interest and who she wants her to date, and discussing with Charlie Adelson, wanting Charlie to intervene with Wendy and encourage her to date a certain person. So I do think it is a theme that reemerges with other evidence.
Well, as the state of mind and motive, I will permit this evidence to be given over objection. However, as to the foundations for these things, Ms. Kappelman, they'll have to be laid through the appropriate witnesses.
Okay, all these items came from a search warrant executed on Wendy Adelson's Google account. The next item, Judge, is, just a moment to locate this. I believe it's 64W, an email dated June 27th of 13. And the objection in this case relates to the characterization of Judge Hobbs as a, can't find the quote, but something like a Southern black lady. They just were proposing redacting that. Find the page for Your Honor. It's redacted, so. It's page 2 of that email. I'll give you 1 and 2. Second page, 2/3 of the way down in the second paragraph, mention of Judge Hobbs. There's no particular relevance to that characterization of Judge Hobbs, so I just don't think it's prejudicial, so I don't know why we're redacting. Whatever Your Honor thinks on that one, Judge.
Folks,
I believe the jury could take that as in a very derogatory way. It has absolutely nothing to do with this case, that comment. Nothing. Unless there's another motive I don't know about.
if in some way, since we do have two jurors of African American descent that would otherwise impute on the defendant a negative character trait, I will permit the redaction for that reason. Beyond that, the item will be admitted.
Next, Judge, is an email dated April 7th, 2015. I believe what's referenced here is 64HH. Yes, sir. May I approach?
You may.
May I have the other exhibit? Judge, this email is a email regarding Wendy moving, and the evidence is gonna show that she moved from a more secure location to a less secure location, so the relevance is sort of gonna have to be developed as the trial goes on, but the idea is that there was no fear for Wendy's safety.
What's the date?
That email is dated,
7/15, I believe, is the last date in the chain.
thank you.
If you have to start the foundation with one witness but enter it at a later point, that is certainly appropriate. What is the objection?
Well, Judge, I have a question. The email that I'm looking at that was provided to us on July the 15th, 2014 is to Jeff Lacoste from Wendy Adelson.
I believe these are from David Trafton at MiamiRealEstate.com.
That's not what we were given.
Can I show the exhibit to the defense?
Please do.
Email that we've been handed is April 7th, 2015, 4:42 p.m. This is regarding Wendy moving. It had the same security as where she was living with her mother, so less secure. There's nothing in here that indicates that.
I'm gonna ask Ms. Adelson about that. My understanding is it is less secure. They're asking lots of questions, but they're not about security, but if they're being actively extorted under threat for their lives, one would expect they would inquire about such a thing.
You may lay the foundation, or at least begin to lay the foundation for that item with when that witness is examined. Going back to the last trial in this matter, when the intent instruction was given, the intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in the case. Specifically, as counts 2 and count 1 that are charged in the indictment deal with aspects of intent. I'm going to find evidence that demonstrates the defendant's alleged motive, which goes specifically to intent, is admissible. One thing, though, that is starting to trouble me with this, we had many motion hearings in this matter, and we've continued this case several times to handle these matters pre-trial. Why is this coming up now?
The exhibit that we were provided with, I went through thoroughly and had all of my objections listed. And then was told that's not correct. It's another binder. It's different emails. The binder I was handed by the state was completely discombobulated, not in date order. It was a train wreck.
As the state's exhibit you're referring to.
That's correct. And so then they provided us with this binder. It appears to maybe still be missing something, but they have a list, an exhibit list, everything laid out by date, by exhibit A, all the sub-exhibit numbers. So that's why, Your Honor.
We're not going to be wasting the jurors' times. At this point, we're 30 minutes behind where we should have been. Are there any other matters that need to be addressed?
There's one more that I asked for, Judge. It's dated April the 20th of 2016, and it's an email about whether one of the children is sad.
64II, Judge, is an email specifically in which the defendant is claiming that the child cannot be sad about the death of his father. Extremely relevant.
Its probative value is outweighed by the undue prejudice, Your Honor.
Compliment again, the purpose this is being offered for is going to motive or state of mind.
Yes, Your Honor.
What is the undue prejudice that the defense is arguing concerning this particular email?
The undue prejudice is what the state is arguing, and they're going to argue to the jury, is that this email says that Donna Adelson said he could not be sad about his father. What she's describing is her time with the child, and she hasn't seen him sad. And it's 2 years after, unfortunately, Mr. Markel was killed.
Ms. Kettleman, if you wish to proffer the testimony from the witness on this, I'll allow you to do so in the presence of the jury, but this one is seeming a bit attenuated.
Mrs. Adelson.
In commenting on how the child is said.
Sure, Judge, but it relates back to the motive and thinking that it wouldn't harm the children. It was going to be good for the children to get rid of their father. Children have no memory prior to this young age that the father was killed. it goes to motive, Judge.
That, I'll allow you to set up your foundation within parts if you need to do so. I'll revisit whether this item can be admitted at that point.
Alright, sir, there's one item that I've added today in light of the opening statement regarding Mrs. Adelson's use of the Skype to facilitate visitation with the father, stated December 18th, 2013. It has been previously provided. It's now marked as State's Exhibit AA.1. While the defense is looking that over, I also have a stipulation of the parties may I approach.
Right.
This will be the first thing. I'd like to have your honor read this to the jury as soon as they come back in.
Can you point out those places?
Sorry, Judge, I've handed them the wrong thing. I'm gonna have to circle back to that. With that, stipulation, we're ready. There's no other issues.
Right, as to 64, I believe D and I did rule over motion that these can be admitted with a proper foundation. As to I believe that's the item that the state is going to, 64 I should say, that's the item the state is going to attempt to lay the foundation for as it relates to motive in this matter.
Yes, sir, I found the relevant portion. It reads from Donna to Wendy here. I'm sorry, from Wendy to Donna. Dear Mom and Dad, here is the phone/Skype plan for the holidays. And she's forwarding a Skype plan from Dan Markel. Please help me do this. It means less stress for me if we just follow it.
I don't know what the relevance of that is. Wendy Adelson sending an email to her mother because her mother takes care of the children very frequently and saying, here's the schedule, let's do this. It doesn't say Mrs. Adelson has not done it.
I think it suggests that Mrs. Adelson has not done it, or at least that there's been issues and problems with Skype and facilitating Skype is satisfactory to Mr. Markel. So I would ask to admit it based on the statements made in opening statement by the defense.
Well, the opening statement is not evidence. The jurors are not considered as such. As to any foundation that you wish to lay for that particular item, that it was not previously followed, and now Wendy Adelson sent that item to her mother, you'll need to establish the foundation first before it's offered. Please bring in the jurors. And I are offered, the limited instruction will be given.
Thank you, Your Honor.
All right, jury, enter in the courtroom.
Everyone can be seated. Members of the jury, I trust you had a restful lunch break. Before we resume with the evidence this afternoon, I'm going to read to you a stipulation that has been agreed upon by the parties. When the parties agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact that you must accept as true is the projectiles contained in State's Exhibits 122 and 123 were examined microscopically by a firearms expert from the Florida Department of Law Enforcement and were determined to have been fired from the same revolver. Ms. Kappelman, you may call your next witness.
Thank you, Judge. The state calls Craig Isom.
Please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. Please speak loudly and clearly for the jurors.
Please introduce yourself and spell your name.
Craig Isom, Craig Isom.
How are you employed?
I'm currently retired.
Congratulations. Where did you work when you worked?
Sent to Tallahassee Police Department,
How long were you with the Tallahassee Police Department?
28 and a half years.
Were you assigned to investigate the murder of Dan Markel?
I was.
How long did Dan Markel live after being shot?
I believe my understanding was around approximately 11 hours.
As part of your investigation, were the people closest to the victim interviewed,
Yes,
including his ex-wife, Wendy Adelson?
yes.
When and where did you approach Wendy Adelson?
She was at a restaurant in Tallahassee on Market Street.
What date and time did you approach her at the restaurant?
That was on the day of the shooting, which was July 18th, 2014. July 18th, 2014. It was approximately 2:15 in the afternoon.
All right, so approximately 3 hours and 15 minutes after the shooting?
Approximately, yes.
What did you say when you approached her?
I told her that I needed to discuss something with her in private. She was with two other individuals at the table.
Two ladies having lunch?
3 total, yes.
All right, and when you told her that you need to speak with her, were you wearing police insignia? Did you identify yourself as law enforcement?
Immediately before I identified myself and said that I was there for the purpose of speaking with Wendy Adelson.
Okay.
And I had my badge on. I was readily identifiable as a police officer.
All right, and did you reassure her that she wasn't in any trouble? Did you?
Yes, I got her to step away from the table she was eating at, approximately 10, 15 feet out of earshot of the other two individuals that were sitting at the table. And I told her that I needed to discuss with her something that happened with her ex-husband and that her children were not involved. I reassured her because the children had already been checked on, they were still at the daycare, and they were fine.
As part of this approach of Wendy Adelson, were there any handcuffs involved?
No,
Any Miranda rights read?
no,
Any use of force at all?
no,
She was not detained or under arrest?
no,
At any time did you tell her she was a suspect in anything?
no,
Was she a suspect in anything at that moment?
no,
At any time during your interview, did you do anything that would treat her as a suspect?
no.
In fact, you told her several times in the interview that she was not a suspect, isn't that right?
I did?
Did you ever accuse her of anything?
No.
Did you provide her with a victim advocate?
Yes.
Is that something that your office typically does for next of kin when a tragedy has occurred?
Yes.
Did you allow her to access her phone during the interview?
Yes.
What did you learn about the victim's relationship with his ex-wife, Wendy Adelson?
They had gone through it and were still fighting in a contentious divorce
I'm going to show
regarding
you
child custody.
with child
Regarding
custody.
including child custody.
All right, I'm going to approach with state's demonstrative A. Have you had an opportunity to review this exhibit before today?
Yes,
What is that exhibit?
it's all of the filings from the divorce case between Wendy Adelson and Daniel Markel.
Starting with the petition for divorce and ending at the time of his death, is that right?
Correct.
And the filings in here, have you had an opportunity to review them?
Yes,
All right, and did this litigation include arguing over things so petty as a tennis racket?
it did.
Objection, Your Honor. Nothing's been entered into evidence, and we would object to the witness testifying to the contents of the file.
Overruled, the witness may testify concerning his personal knowledge of the investigation. Continue.
Thank you, Judge. As part of these proceedings, did Wendy Adelson seek to relocate with the children from Tallahassee to South Florida?
She did.
Did she say why she wanted to relocate to South Florida?
Objection, hearsay.
Staying, the answer would call for hearsay unless you have an exception.
I'm going to show you what I've marked as State's Exhibit 60. Have you had an opportunity to review State's Exhibit 60?
Yes,
Are those the portion of the divorce filings contained in State's Demonstrative A that can be directly linked to Donna Adelson?
yes,
Meaning she saw those items.
yes.
Objection, lack of foundation.
I believe that's what Ms. Cattleman is doing right now. Overruled. You may continue, Ms. Cattleman.
Move into evidence, State 60, Your Honor.
Please approach. Please be seated. What's that? You can step down, Mr. Ison. Please step outside the courtroom. Sure. All right. At this point, I'm nearing becoming inclined to send the jurors home for the day, as we are wasting a significant amount of time on matters that were either previously litigated or now are still being challenged for reasons that could have been handled out of court. Mr. Zellman, for any item that is being objected to with State 60 that you are claiming has no tie to your client's communications, you need to look through that binder now.
Judge, part of the objection that we're making concerning that is without laying the foundation through a witness with personal knowledge, there is no tie to my client. Anything, and specifically anything post-dissolution, so post July 31st of 2013 that's in here, there's no evidence.
I heard this argument previously.
Yes.
It has been ruled upon.
Yes.
At this point, if the state has multiple witnesses that the foundation can be laid through, your objection will be noted for the record, but we are going to move on. If you need to look through this binder to match it up with specific communications in which you believe no foundation can be laid, you'll need to take the time. But as far as wasting the jurors' time on this any further today, what else does a defense need to look through concerning these exhibits? Before we leave here today, if we need to go through every single state exhibit to deal with any objections concerning them, we will do so, however long that takes. But we're not going to be wasting the jurors' time.
Just a moment. to our objection concerning establishing the foundation for proving my client's knowledge, we're ready to proceed.
Concerning that, Ms. Kappelman, between former Detective Isom, Wendy Adelson, or any other witnesses, are you going to be establishing the foundation as to the defendant's knowledge or connection through multiple witnesses?
May I have a moment, please?
Go ahead.
Judge, I had not planned to do that. I provided this exhibit to the defense. I had not heard anything about an objection, so I had not planned to go through every single piece of paper with this witness. I can do that, but that is gonna take some time. I will need a recess to prepare for that. I do have a list of how each piece of paper is related to the defendant, but this witness isn't prepared to go through every single piece of paper in this exhibit.
Are you requesting for me to send the jurors home for the day?
No. I think I've complied with the court's ruling, and I'm requesting that the exhibit be admitted pursuant to that, and we move on.
There does have to be a foundation as to the nexus between the defendant's either communications or actions and these pleadings. That was the ruling. For what was provided in discovery,
Is that something that needs to be done in front of the jury, Judge, or is that something we could tie up later and move on right now?
you can tie up later, but it will not be admitted until the foundation is tied up.
Okay, Judge, I think that would be my preference then.
Very well, please bring the jurors up. Please direct Detective Isom to come back in and take the stand. Detective Isom, come back in.
All rise, jury enter in the courtroom.
Everyone can be seated. You may continue your examination, Ms. Kappelman.
Thank you, Judge. Now approach with State's Exhibit 64. Do you recognize State's 54?
Yes,
How do you recognize it?
these are the emails, I believe.
Take time.
believe these are from Wendy Adelson's computer.
Was a search warrant issued to Wendy Adelson's Google account?
Yes.
And did we receive emails subject to that search warrant?
Yes.
And does State's Exhibit 64 contain fair and accurate copies of emails between Wendy Adelson and Donna Adelson?
Yes.
Alright, and if you'll turn to the yellow tab there. In particular, are you familiar with this email? And for the record, Judge, this is tab AA.
This is. Yes.
Is that an email that was sent from Wendy Adelson to Donna Adelson? On the bottom.
This is from Donna.
Well, okay. It starts out as something from Danny, right?
Right. Dan sends this email to Wendy,
Okay.
and
what
it's
is-
CC'd to another individual.
Okay, and what does Wendy do with it?
She forwarded it to her mother.
Okay. And is the content of the email related to what we referred to as the grandma motion?
Yes.
What is the grandma motion?
This is where Dan
Judge, Your
Markel.
Honor,
What is the objection?
First of all, lack of foundation, and it's hearsay at this point.
Overruled as to lack of foundation. The investigator may testify as to his personal knowledge of the investigation. Concerning hearsay, Ms. Kappelman.
Did Mrs. Adelson respond to this email?
Your Honor, gonna object again. Mrs.
One
Adelson.
moment. Members of the jury, the bailiff is going to take you out. Investigator Ison, if you could step down, please, sir. So, not to sound like a broken record, but that part where the jurors need to go home so the issues concerning these documents could be worked through, concerning that, Mr. Zellman, what is your position?
Judge, I've said all along.
I know what your argument is, but as to the items the state is seeking to admit today, are there going to be more challenges of this nature? If you have objections, I will rule on them, but we're not going to waste the jurors' time.
Judge, as to 64AA, my client and her husband shared an email address. There's no evidence as to who sent the response that the state is trying to get to.
How many parts of 64 is the defense objecting to?
Just AA, Your Honor.
Cavalry, concerning AA, does the foundation need to be laid amongst multiple witnesses, or is Detective Ison capable of doing this?
As far as to whom the email address belonged, that will have to be tied up with Wendy Adelson.
Very Well, is there any other parts of Exhibit 64 that need to be dealt with now while the jurors are out of the room? Please look through it.
Just AA, Your Honor.
Are there any other exhibits that pertain to Detective Isom that need to be dealt with while the jurors are out of the room?
Would you like to know what items I intend to introduce, Judge, through him?
Please, so we can handle these objections now, and there will not be a constant back and forth where the jurors need to leave the room.
Exhibit 55. Show that.
I think we stipulated for that.
Well, 60 is the divorce excerpts, which again, we're going to deal with separately. The email, 64, my understanding is we're going to deal with AA, and then the rest of it is going to come into evidence with this witness at this time. 65, Mr. Rivera's ticket, which is certified. 66, Garcia's ticket, which is certified. 67, Save Gas records with certification. 68, Adelson Institute records with certification.
Are there any objections by the defense that need to be handled out of the presence of the jury concerning these items?
No, Your Honor.
There's a couple more, Judge.
Go ahead.
89, Premiere video clips. 90, bus video clips. 119 is a thumb drive containing the raw data from Premiere, and 120 is a thumb drive containing the raw data from the bus.
No objections to those, Your Honor.
Please bring back in the detective.
That.
As to AA, whichever portion of the foundation you're capable of laying with the detective, you can at least start it with that. As to the rest of it, you can seek to admit it if the foundation can be laid without it, or without any other witnesses. Please bring back in the jurors.
All rise, jury entering the courtroom.
Everyone can be seated. You may continue with your examination of Mr. Isom as it relates to the foundation.
Mr. Isom, you, I believe, previously indicated that you reviewed the divorce file as part of your investigation,
Yes,
and that's the court file.
yes,
All right, and as part of your investigation, did you review the emails that were subject to Wendy Adelson's Google search warrant?
yes,
And in those emails, was there an email in which the contents of, well, let me ask you first about the motion. Did you review a motion where Dan Markel was seeking to restrict Donna Adelson's access to the children?
yes, I did.
All right, and that motion was filed with the court.
Yes,
It was pending at the time of his death.
yes,
And did you find in the emails any evidence that the contents of that motion were sent to Donna Adelson?
yes,
And is that tab AA of State's Exhibit 64?
yes,
And are the contents of that email substantially similar to the allegations made in the court filing?
substantially, yes.
Okay. And what is the gist of what it is that Dan Markel is requesting?
He does not want Donna Adelson to have unsupervised contact with his children
Why not?
because of the statements that are made in here and that was shown in the court filing, that the children reflected that grandma says you're stupid, grandma says she hates you.
And
Judge.
I simply do not read from any document that has not been admitted.
at this time, Judge, I would ask to admit State's Exhibit 64.
All parts or just the part that does not include AA?
Subject to tying up AA, I would seek to admit the whole thing.
States 64, any objection?
Just the objection previously made, Your Honor.
Concerning States 64, it will be admitted except for Part AA and any later foundation that needs to be addressed.
Did, in your review of these emails contained in State's Exhibit 64, the defendant, Donna Adelson, use any strong language against Dan Markel?
Yes,
Did she call him any names?
yes,
I would ask you to review State's Exhibit 64, tab DD. Do you recognize that exhibit?
yes.
What email is that?
This is from Donna to Wendy.
And does she call Dan any names in that email?
She calls him Elvis.
How about asshole?
I know it's in here.
Take your time.